I can't say that I'm sorry. To be honest with you, I feel so bleeping great. Those are the words of a son to a 911 dispatcher after he just shot and killed his own father. This 27-year-old man just learned his fate in court. There are a lot of questions you might ask yourself when you see a story like the one I'm about to tell you. Questions like, how does this happen? How does a relationship between a father and a son get to this point? How does a son kill his own father? And not just that, then call police and show no remorse for what happened. Let me lay out what started in 2022 and just came to a conclusion with a verdict in Texas. This is Yacob Hickman. He's 27 years old. He'll never see a day again as a free man. He was convicted last week of shooting and killing his own dad in 2022 in Canyon Lake, Texas, which is not far from San Antonio. Before I get into the details of what happened, I want to talk about what we know about the victim, the killer's dad, who did seem like someone who was truly beloved. His name was Paul Stautzenberger. Here's his picture. He was 51 years old. According to a GoFundMe page that was linked by his brother on Facebook in 2022, a post read that, quote, Reverend Paul was a master mason, Texas master gardener, Texas master naturalist, Texas master beekeeper, and active member of the Sons of the American Revolution, York Rite, Eastern Star, and the Shriners. But Paul lost his life at the hands of his own son. Police say the killer, Hickman, had moved to Texas from Louisiana just a week before the shooting at the encouragement of his dad, believing if he moved, he'd have a better chance of finding work. Hickman called 911 shortly after the shooting. I have requested the audio recordings from the local district attorney's office, but at the time of this recording, we haven't received them as of yet. But I'll tell you what police say he said over the phone. Those words are chilling. This is what the local district attorney says that Hickman told them over the phone. Hickman told the 911 dispatcher he, quote, emptied 6 rounds into his father and added, I can't say that I'm sorry. Hickman remained on the call with the dispatcher for over 20 minutes, acknowledging that he should control his anger and that he was fully aware of the consequences of his actions. During the call, he also stated, quote, to be honest with you, I feel so bleeping great. This is a man talking about his own father who he just killed. Police say Paul was eating a salad on the couch when he was murdered. But that's not all Hickman said. During trial, prosecutors played some of the phone calls that were recorded while Hickman was behind bars, where he was explaining why he killed his dad. Hickman stated that he and the victim were having a simple conversation, but said the victim, quote, kept on wanting to run his bleeping mouth. Prosecutors say after sentencing, family members in court said that Hickman killed the one person who truly wanted him to succeed. Joining us now to talk about this case is trial attorney Bridget Williams from Dallas, Texas. Thanks for taking the time to be with us. It is shocking what Yacob Hickman apparently said in this phone call to the 911 dispatcher. Have you ever seen something like this?
I have not. I have not. Directly after committing the murder, you call 911 and give a admission of guilt to the extent of that you have no remorse at all whatsoever, and even tell them the details of how many rounds you fired into the father. So I have not seen anything like this. So it's definitely an interesting case, to say the least.
Yeah, to say the least. Said he felt great, with some colorful language in there as well. One would look at this, killing your father, and then making this phone call that this is someone who is not in a sane state of mind. Why not, and now that he's been found guilty, he'll spend the rest of his life in prison. Why not make an insanity defense if you were the criminal defense attorney in this case?
Well, when we go back to just even the 911 call, the 911 caller asked him, I wrote it down because it was so interesting to me. Were you fully aware of the consequences of your actions? And that right there is enough to eliminate an insanity defense, because an insanity defense pretty much is just saying, do you understand right from wrong? Do you understand what you did was right or wrong? And if you fully understand the consequences of your actions, and the answer to that is yes. No one was there to force him to say those words. No one was there to bribe him into saying those words. He did that of his own accord. And so based off of that, that's enough there to eliminate a insanity defense.
And I'm not sure what specifically how the criminal defense team tried to take on this 911 call, because it appears that it was so damning. But can the argument be made that, look, he did this, it was in the moment, he makes this phone call, didn't realize what he was doing when he admitted to all of this? How could a criminal defense team try to, I guess, stop some of the damage that this 911 call could have if you're trying to defend him in court?
So well, we're not privy to the exact 911 call, but sometimes we're able to get portions of the 911 call not allowed into evidence. If it may be hearsay or if there's something that's not admissible in evidence. However, the statements that he made are admissible. They're not hearsay. It is something that he stated himself. It's not. There's no exceptions to it to make it be hearsay. And so it's nothing that really the defense counsel could have done to taken that out of evidence. And so as a defense attorney, sometimes it's our job to try to lessen the blow, try to reduce the punishment phase as much as possible, and give the client just as much advice as possible.
How common is it to have a someone who's committed murder just show no remorse for what happened?
I think that's a case by case basis. Sometimes you have individuals who may have committed a murder and they may have done so because of actions that the alleged victim may have had with them. You never know what's going on. So again, that's a case by case basis. Sometimes it's just the person who does it out of spite, anger, hurt. You never know what the motives are. And the thing is that a motive is not an element for a guilt or innocence phase portion of a trial setting. And so that's not something that's required. However, it is something that goes into consideration, I believe, in a punishment phase. So depending upon if you go to a jury or a judge, the judge or the jury is going to take into consideration what that motive was. And if you don't even have a motive, and you do it with no remorse, you just do it blatantly, intentionally, I think that definitely goes into that.
I want to dive more into what it takes for someone to be considered by the law to be insane. Because for, I think, the general public to take a life and to do it in this way, you would say this person's insane to do this. But how does the law, what is the bar that someone needs to meet to be considered insane and to have that type of plea in court? Because often it's hard to understand in some cases why someone is considered insane in the court and then why someone isn't, and they're held accountable for a crime like murder.
So it really just it plays out differently. The short answer is, do you understand right from wrong? That's the short version. In real life, we have just insanity. You can have hearings where each side may have a person who's a specialist who does an interview with the defendant and determines if they are capable of standing trial, and they give their opinions about it, right? And so and then a judge hears that and the judge decides if that person is competent enough to stand trial or if the person is not. And so it just depends. But the short answer is, do they understand that their actions were right or wrong? Do they understand the difference from right and wrong? That's a short version.
They also apparently played jailhouse phone calls that Yacob Hickman made, where he had said that, I guess, part of the reason that he did this was that his dad was, I'm not directly quoting it, saying that he was running his mouth. Um, how is it that defendants just don't seem to understand that these phone calls are recorded? Because you see this.
Um, I do see that a lot. I do see that a lot. And it's an interesting thing that people will say everything under the sun, especially immediately after an arrest. People will, call their loved one, their wife, their mother, their, just other family member, and tell them, I'm so sorry I did this, or I did this, or admission over the phone. And so when they do that, everything that you say on those phone calls, if you're not talking to your attorney, can be admitted into evidence. And so they are recording every last one of those phone calls from the moment that you walk into the jail. And
I,
so that happens frequently.
Are people told that because you make a call to customer service for like a flight delay, and the airline tells you that this call may be recorded? Is it like that in jail too?
I don't think so. They don't necessarily have to tell you that, and a lot of
Okay.
people don't always are made aware of that. So they may get on the phone again and just start talking, but not have knowledge that that is something that could be used against them at a later time.
And what impact do you think those jailhouse phone calls could have had? I know we've talked about this, and look, this seemed like it was a pretty open and shut case from the 911 call. But then it stands out to me too that he was making jailhouse phone calls. When you say I did it because my dad was running his mouth, that doesn't really show much remorse either. And then that is after the fact, where even if you tried as a defense attorney to say this 911 call, it was just heat of the moment that he said these things. I mean, he's still, I don't know how long after it was, but certainly a period of time not showing any remorse for what he did.
Right. It just adds heat to the fire, right? What I would say is that it's definitely admissible, and it's something that the state would use in their prosecution to show that he did this again with no remorse intentionally, and that he knew exactly what it was that he was doing. So that even further negates that of that insanity. You stated on multiple times that you did this intentionally on more than one occurrence.
Texas has a reputation when it comes to the death penalty. The state of Texas and the law. It does not appear from the court records that I saw that this was a death penalty case. Why do you think that is?
So, not all murder cases rise to the level of capital murder. In order to get to capital murder, which just allows for somebody to get the death penalty as a possible punishment, there has to be certain requirements that are met. There's a list of murders that have to meet. You have to meet these particular elements in order for somebody to have the death penalty as a possible punishment. And in this situation, they just didn't. Some examples of that would be if you murdered someone who was a child or a police officer or multiple murders, or there's a list of things. And just in this point, for this particular case, it doesn't rise to anything that's on that list.
Take me inside, because I started in the intro to this thinking of some of the questions you have when you just read a story that's as shocking as this. And one of them is just, how does a family relationship
Mhm.
get to this point? And there are a lot of questions that we'll never know. When you look at this family dynamic and for it to end the way that it did, what stands out to you?
There has to have been some things going on that we were just not privy to, right? And maybe those things may have come up during the trial setting, and we just don't know that information. But things like this, in my experience, don't just come up out of the blue. And so we don't know what it was happening in the background, but I'm sure that there was some family dynamics going on there that we just don't know about. Nothing at all gives just rise or gives motive, no matter what the family dynamics were, to killing your father while he's sitting on the sofa. No matter what it was, I don't think it gives for the result that came from this.
One thing when I see these horrific cases, and I often wonder for the attorneys who have to defend someone who clearly has done this crime just based off the evidence that we saw. Just as a person and your job as a criminal defense attorney, how do you get into the mindset of defending someone who has done something so horrific?
Chris, when I was a young attorney, I asked this question to a mentor of mine, and it's his response has always stuck with me. And that response was, "Your job is to defend their rights. Every person has a constitutional right to have justice being served on their behalf. Every person has a constitutional right in order that the criminal justice system works the way that it should, and make sure that the state does their job and prove all the elements of that particular crime that they are accusing that person of." And so that's how you have to think about it. And that's in every case. So if you're talking about a capital murder case or a DWI case, no matter what it is, it's our job to make sure that we are defending their rights.
No, it's really well put, because I often think about that, and it's not just in a case like this. I mean, for us at Law and Crime, I mean, every day we come across, as you know, as you've been a guest here many times, we come across some really tough stories we have to talk about. And I always think for those criminal defense attorneys, That at some point, when it's certainly clear cut, like in this case, just how do you do it, especially when it goes on? I mean, this case just ended last week, and it's been going on since 2022. We are trying to get the 911 audio recordings. And I'll just ask you, as you know how the state of Texas works, and I know it's just different counties and that can be different. How willing typically are district attorneys' offices to give out that type of evidence after the fact, now that the case is over?
I would say not always willing to do so. And so that information normally is distributed by the police department, not necessarily the DA's office, in an open records request. And that's if, the police department determines based on the open records request if that's something they can give out. And so it is a county by county basis, sometimes city by city, depending upon who is the police officer or department that is handling it. So it just depends.
What is typically the argument that you've seen, and even in cases perhaps that you've worked on, where there is that evidence that might have been played in open court, but you don't want to see it out in the public? What would be the reason behind that?
Reasons why we don't want to see it out in the public?
Yeah.
Yeah, well, sometimes we want to make sure that the main reason, as a criminal defense attorney, you don't want to slay or taint your jury or your potential jury for your client. So if it's pretrial, right, you don't want to taint your jury. So people who are watching it on the news, one of those people can be a potential juror. And if they're taking information from the news or from any type of news outlet, social media, or news that's online or on television, then without having the scope or the perspective from defense counsel, they can take that any way that they so choose. That's why whenever people become jurors, the judge generally informs them, please do not read about this case on social media. Not even please, he tells them, do not read about this case on social media going forward, because it's at that time, it's their job to listen to the evidence that is presented in court and only use that information to make their determination for the guilt or innocence phase. And so if they're focused on things that they have seen previously through the news and they don't have the full context, then that could definitely taint that jury.
Yeah, so I know I put you on the spot a little bit there with that question. As on our end, we're trying to, we always try to get as much information as we can as we cover stories like this, even difficult stories like this one. Bridget Williams, trial attorney. Always great to have you on Law and Crime. Thanks for being here.
Thank you for having me.
The 27-year-old Hickman is serving a life sentence. For Law and Crime, I'm Chris Stewart. We'll see you next time.